First of all, good evening, everyone, and welcome to this evening's webinar. Thank you very much for joining us. Can I just ask you all to just give me a virtual wave just so I can check you can hear and see me okay? Perfect. Thank you very much. So I know I will be an unfamiliar face to most of you, and Tiffany's kindly handed over the reins to me just for this webinar so I can introduce myself to all of you. My name is Laura Kai, and I've recently taken over as events coordinator for the Young Animal Lawyers Network. And for those of you who don't know, the Young Animal Lawyers Network, or YAN, is a network for early career professionals who are interested in animal law. And we offer support and guidance for those who wish to get involved with animal law in either a pro bono capacity or professional capacity. We provide and host events which would be of interest to aspiring law professionals, animal law professionals, and help to provide research opportunities in support of A-Law's work as well. We accept members who are law students, undertaking pupilages or training contracts, and those that have up to 5 years post-qualification experience. And we currently have a number of really exciting events in the pipeline. So I will pop our email address into the chat box. So if you're interested in joining us and finding out a little bit more about what we do and how you can get involved, then please do feel free to drop us a line. I'm very conscious that you didn't join this evening to listen to me go on at you for an hour. We're very excited to be joined this evening by Katerina Stoykova, who's going to speak to us about protecting animal dignity. And I must admit, I've had a sneak peek at her presentation, and it's such a fascinating topic, and I know you're all really going to enjoy the talk this evening. There will be a few moments at the end for a Q&A session, so you please feel free to submit any questions that you have using the Q&A function at the bottom of your screen. You can choose to submit questions anonymously as well if you wish, and we just want to make sure that we keep the chat box free. So, Katerina studied law at the University of Zurich and works for Recht, or the Foundation for Animals in the Law in Zurich. She is a board member and on the committee for the popular initiative against factory farming in Switzerland, and she also works as a musician. So without further ado, I will pass you over to Kate.
Thank you so much, Laura. Thank you. So before popping up my presentation, I just want to say thank you so much for inviting me to speak. Thank you to the UK Centre for Animal Law, and especially Paula Sparks, who initially invited me to speak on the occasion of the bicentenary of the Martins Act. But also, thank you so much, Tiffany Mitchell and Laura Kai, for helping me before this event and supporting me. So without further ado, I will begin my presentation. Yeah, this is it. Okay. So I'm just gonna give you a brief overview of what I'll be talking about, what we'll be looking into. We'll take a quick look at Switzerland as a country and the legal system we'll be talking about. Then we'll look into the Swiss animal welfare legislation and its scope, before going into a more detailed look at what the animal dignity concept means and who it actually protects in Switzerland. Finally, we'll discuss some recent political developments that are either directly or indirectly related to animal dignity protection. Okay, first off, why is this not working? Yes, it is. First off, a little bit about Switzerland. Switzerland is a very small country in the middle of Europe, but not a member of the EU. We have 8.7 million people at this point. And Switzerland is divided in 4 language categories, which are also to a certain degree have 4 different areas with different habits and customs. We have a German-speaking part, a French-speaking part, an Italian and Romansh-speaking area. The most important difference to the English-speaking area of the world would be that in Switzerland, we have the civil law tradition, meaning that courts and other judging bodies apply statutory law, and the legal principles are embodied in codes and statutes and ordinances, such as, for example, the Animal Welfare Act and the Animal Welfare Ordinance, rather than through precedent, as is the case in the English-speaking part of most of the English-speaking part of the world. Statutory law is designed to cover all eventualities and basically has precedence over custom and judicial decisions. And so consequently, courts and civil law systems have a more limited role of applying the law to the case at hand. And their decisions do not have the same binding character as in common law systems, and they can be overruled. Also, the writings of legal scholars carry a great deal of authority in the civil law system in Switzerland. Even though they are not a formal source of law, they serve as interpretation guides. And we'll see that this is also important for the animal dignity concept. So these writings of legal scholars also have great influence on the development and interpretation of law. Switzerland is a semi-direct democracy, meaning the popular vote. Popular votes are highly developed, in particular the popular initiative to change the constitution and the possibility of national referendums to change federal laws. And these two institutions, or these two tools, have proven to be a constant driver of improvements in the protection of animals, as in other fields as well, in other legal fields. Especially the popular initiative serves as this vehicle for change and innovation within the political system. So with the instrument of the popular initiative, a popular vote can be held with regard to topics that find no majority in parliament. And so an impulse can come either from a parliamentarian, from the general population, from animal protection organizations, and other interest groups. And of course, most of these initiatives, unfortunately, are not successful, but they do, however, spark national debate. They change the mindset, and they're an impetus for maybe future change on a national, on a federal level, on a federal law, legal level. For example, Switzerland has so far rejected 4 initiatives to abolish or at least drastically reduce animal experiments. So far, they've never been successful, but what it has done is actually brought this issue to the forefront of political discussion. So a lot of people have been talking about this. People that have never, had anything to do with animal welfare or rights issues at all are suddenly discussing these things. And we'll look into other initiatives that have been more recent, that have recently been a topic. A similar instrument, as I was saying, is the national referendum, which can be used to challenge an enacted federal law. And so in order to ensure that a federal law would survive a possible referendum, there's always a consultation process that takes place prior to its enactment, and whereby all interested parties are invited to present their positions on the topic at hand. And this is a way to possibly influence legislation, at least to a certain degree. So this semi-direct democracy gives people quite a big chance to change, fundamentally change legislation and the constitution in Switzerland. Also, something which is worth mentioning in this context, and which I'm already mentioning now, because it so strongly contradicts reality, is the fact that Switzerland, and especially animal ag industries, are very proud of the Swiss, very strict animal welfare legislation here. And there's this constant mantra of about Switzerland having the best Animal Welfare Act in the world, and it's always being used to influence the population within the context of initiatives, to tell them we don't need this new protection law, we don't need this change or this amendment, because we already have the best Animal Welfare Act in the world. And it's something people are actually repeating because it's constantly being served to them. Okay, so I want to give you a quick overview on the animal welfare law in Switzerland, because as most countries, or many countries in the world, have animal welfare acts, so does Switzerland. Just to show you a little bit, before going into more detail into the dignity concept, I just want to look into the animal welfare law as a whole. So there's a constitutional basis for the Animal Welfare Act, which was adopted. It was a provision, Article 80. It is a provision, Article 80, in this federal constitution. It was adopted in 1973. And this meant, after this adoption of animal welfare into the Constitution, it meant that animal welfare, the protection of animals, became a national objective. And also, what's worth mentioning is the fact that it became a constitutionally protected interest equal to all other constitutional objectives and principles, most importantly, also equal to fundamental human rights. So animal welfare and other national objectives are of equal value. Most notably, the human rights that would potentially oppose animal welfare interests would be personal freedom, freedom of religion, academic and economic freedoms, and so on. It also meant that animal welfare became a federal mandate. It meant that the legislator was obligated to enact animal welfare laws based on this constitutional provision. Yes. And this is exactly what the legislator then did. In 1981, the first animal welfare laws, the Animal Welfare Act and the Animal Welfare Ordinance, were enacted, and were later on, years later, in 2008, they were completely revised. When the first Animal Welfare Act was introduced, it did not yet protect the dignity of animals, as is the case today, and as we'll be seeing later on. And its purpose article was limited to the protection of the well-being of animals. And it was not until 2008 that actually animal dignity was enshrined in the Animal Welfare Act. The most notable changes to the Animal Welfare Act within the scope of the revision in 2008 were more detailed husbandry provisions, more extensive training and further educational requirements for animal owners and keepers and guardians, the inclusion of provisions on the keeping of equines, and so on. However, it must be stated, as with everywhere else in the world, the revised animal welfare legislation still sets only minimum standards and does not fully guarantee species-specific treatment of animals, contrary to what is always being said by politicians and also by the federal government in Switzerland and the animal ag industries. And it's also worth noting that although it is true that the Animal Welfare Act in writing is quite strict and has very far-reaching regulations, it's undermined to a certain extent, or to a very far extent, by the Animal Welfare Ordinance that has regulatory provisions which primarily serve user interests. So, as we'll be seeing later on, we have the protection of the dignity of animals, which is this, this big, this very far-reaching protection for animals in the Animal Welfare Act. But at the same time, we have all these practices that are still allowed. We're still killing baby chicks the moment they're born. We're still dehorning cows and other and using farm animals on a mass scale, and so on and so forth. So it's a nice to have, but what's actually happening in practice and what's actually being allowed through these regulatory provisions contradicts the basic principles of the Animal Welfare Act. And we'll look at this in a little bit more detail. Okay, so today, we're talking about the Animal Welfare Act today. Its purpose is to protect the dignity and well-being of animals. This is what it says, and this is the purpose article of the Animal Welfare Act. And it's noteworthy. It's worth mentioning that the protection of dignity is the first thing to be mentioned. It's mentioned before the well-being of animals. So it's a very important principle of the Animal Welfare Act. What it means is that it is forbidden to disregard an animal's dignity, and I'll explain what this means, how this is defined. And it also means that it is prohibited to inflict pain, suffering, harm, or distress on animals without reasonable cause, as is the case in many other places in the world. This is a very typical prohibition in a typical welfare act, Animal Welfare Act. Then the scope, I think it's quite important to note what animals are actually being protected at all in the first place. So the scope of the Animal Welfare Act is as follows. The protection is only granted for vertebrates in general, so mammals, birds, fish, reptiles, and amphibians, and only for invertebrates that have been proven to be sentient and capable of feeling pain. So as long as there's no proof of sentience, animals are not protected by the Welfare Act, which in our opinion is quite questionable, because there should be kind of a benefit of the doubt, but that's not the case. So the two other categories of invertebrates that have been deemed worthy of protection are Reptantia, I hope I'm pronouncing that correctly, and those would be lobsters, crabs, crayfish, and the likes, and cephalopods like squid and octopuses. All the other invertebrates are not protected by the Animal Welfare Act because they have not been proven to be, well, there is data that shows they have avoidance behavior, which can be equated to the capability to feel pain, but still it's considered that they are not sentient. So we have 95% of all animals are not protected by the Animal Welfare Act. All the insects lack protection, gastropods like snails, and arachnids and like spiders, they all lack protection. And it's problematic because many of these animals are also being kept as companion animals or pets in terrariums, or they're being commercially kept, or they're being killed on a mass scale within the scope of pest control. And all this is happening without any protections in place for these animals. They are, however, and we'll get back to this in a little more detail. They are, however, protected via the constitutional principle of dignity protection for living beings. But because there's no legislation on their protection based on this constitutional principle, in practice, there is a total lack of protection for them. Also, I think it's worth mentioning, because it's so contradictory, because the scope of the Animal Welfare Act, the purpose of the act is to protect first and foremost the dignity of animals and their well-being. At the same time, their life is not protected. There's no guarantee for life protection, which I find very irritating and contradictory. Unlike, let's say, countries like Germany and Austria that specifically protect the life of animals in their in their Animal Welfare Acts. However, of course, with proper justification, this protection can also be violated, as then the prime example for this would be, for example, food production, right? So it doesn't mean that much, but it's still, I think, noteworthy that the same act will protect the dignity, but will not protect the life of animals. So in Switzerland, killing animals is legal as long as the animal is not subjected to any pain, meaning as long as it is rendered insensitive prior to being killed, prior to being euthanized or slaughtered, and as long as the killing process conforms to law, meaning that it has to be performed by someone with the necessary skills and according to certain rules provided for by the animal welfare legislation. It's prohibited to kill animals in a cruel or wanton manner or in the context of animal fights. The wanton killing of animals is the closest we've probably ever gotten to a form of life protection, because what it means is that it's prohibited to kill animals out of spite, revenge, or for fun, let's say. And so this is an example for this. For the importance of this provision would be the case if an animal guardian looking to get rid of a companion animal they no longer want to care for. That would be a case for a wanton killing. If they would just say, look, I just don't feel like it anymore, I'm bored, euthanize it. And here it would have to be examined on a case-by-case basis to see if this is really a wanton killing or if there's some reason for this guardian wanting to euthanize their animal, because again, life isn't protected as long as the euthanasia happens in with anesthesia. Then it's legal. So there courts or judges and prosecutors would have to prove that this was a wanton killing of an animal. So cases here are very, very rare because it's kind of difficult to prove if someone wants to kill their animal out of spite or revenge. Also, veterinarians are obligated to follow a code of conduct which prohibits euthanasia for no reason, but it's worth mentioning that this is not a legally binding code of conduct. Okay. Now I'd like to go into the animal dignity protection. This was a quick overview of animal welfare law. Animal dignity protection. First of all, before I go into its definition and how it's and its meaning and the historic development, I would like to look into its adoption into Swiss law. In 1992, the principle of protection of the dignity of the creature. That's how it's directly translated. The principle of the protection of the dignity of the creature was enshrined in the Swiss Constitution by way of a national referendum. And Switzerland became the first country in the world to take up this protection of the dignity of the creature, or of living beings, as we'd say, into its constitution. Article 120 of the Swiss Constitution stemmed from a popular initiative that demanded greater protection against abuses of gene technology, and stipulates that the dignity of living beings must be taken into account in regulating the use of reproductive and genetic material derived from animals, plants, or other organisms. The dignity protection for living beings, this principle, thus became a constitutional principle with validity beyond gene technology and throughout the entire legal system, and was from then on considered to be a principle that should guide state action in all areas of where humans and animals have any sort of relationship. So the protection of animal dignity on this constitutional level, to a certain extent, curbed the legal order's dominant anthropocentrism up to this point, which was quite a milestone. And then, as I was saying before, in 2008, this principle of dignity protection for living beings was adopted into the Animal Welfare Act, and it was stated that the purpose of the act is to protect the dignity and welfare of animals. But what does this dignity protection mean? it sounds so nice, but what is it? So the meaning and scope, I'll focus on Swiss law and the Swiss interpretation, because of course it's a huge international issue and a philosophical concept we just don't have time to get into today. But the roots of the term dignity of living beings as used in our constitution are mostly theological. The term was first coined by Danish philosopher and pastor Laudit Smith in 1789, who wrote that every living being exists for its own sake, and believed that God had endowed animals and humans with the right to enjoy life and a right to happiness. In 1945, Basel theologian Karl Barth shaped the dignity concept and spoke of a dignity for all living creatures due to them having been created by God. So it's obviously quite theological in its background. Under the Swiss constitution, the dignity of living beings refers to the inherent value of a living being, meaning that the dignity is a permanent trait. It cannot be acquired or lost, and it is non-transitory. So it is something that's inherent, and it is not given, it cannot be given or taken away. And like humans, non-human animals exist for their own sake and not for human purposes, and their species-specific characteristics, natural needs, and behavior patterns. So the introduction of the concept of dignity of living beings contradicts the traditional idea that only humans have dignity and brought in a new biocentric element to animal protection, which was exclusively anthropocentric prior to its inception. However, the current definition in Switzerland follows the belief that animal dignity is of relative nature, in contrast to human dignity, which is considered to be absolute. And here there's debate between different schools of thought. Certain authors draw an analogy between the dignity of the creature and that of humans, while other authors make a conceptual distinction between the two. This relative nature of the dignity concept within the Swiss constitution is highlighted in the following, and something I want to quote real quick. The audit committee of the Council of States issued the following statement shortly after the adoption of the dignity protection for creatures, for living beings in the Constitution. This is what they stated, quote, "Animals are to be treated neither as humans nor as things, but in accord with their dignity as living beings and according to the autonomous standard of their own needs. It is in this regard that their feelings are to be respected, their suffering reduced or avoided altogether, and their will to live respected. This emanates, for example, in the restrictive usage by humans," unquote. So they end this statement by, on the one hand side, stating that the usage of humans is to be restricted, but they're not questioning the usage by humans in general, right? So the dominant understanding of animal dignity under Swiss law follows the school of thought that animal dignity should be viewed in a way that is fundamentally different from the concept of human dignity, because it would otherwise have too far-reaching consequences and would not allow the use of animals by humans. So Parliament and the government and all those responsible for enacting, for interpreting this constitutional principle were very, very careful not to go too far, because if we would follow, in our opinion, much more logical interpretation of the dignity concept, and would say that in its core, animal dignity and human dignity can't be two completely different things. It doesn't make any sense. It's the same word. You would use another, just, as something as banal as that, you would use another word for it. You wouldn't be calling it dignity if it's something that is fundamentally different. So Switzerland, in that sense, continued to follow an overall anthropocentric interpretation of the law. So after its adoption, here we were speaking about the dignity, the principle of dignity, animal dignity protection within the Constitution. And now I'd like to look at the definition within Swiss law, within the animal welfare legislation and its scope. So Article 3 of the Animal Welfare Act defines dignity as the inherent worth of the animal that must be respected when it is being dealt with. This means that every form of stress imposed on an animal constitutes a violation of animal dignity. A violation of animal dignity, which cannot be justified by overriding interest, constitutes a legally relevant disregard for this animal's dignity. So the Swiss animal welfare legislation differentiates between a violation of animal dignity and a disregard for an animal's dignity. While not every violation of animal dignity is considered punishable or considered unlawful, every disregard for an animal dignity is considered unlawful. And what constitutes disregard for animal dignity? A violation that cannot be justified by user interests, by human interests. So this requires a balancing test. Every use or every action involving an animal requires a balancing test between the animal's dignity, between a potential violation of its dignity, and a potential benefit on the other side. And then there has to be this balancing of these interests. And if the user interest outweighs, in this case, then the violation would be considered lawful. If it doesn't outweigh the dignity of the animal or the interest of the animal in not being violated in its dignity, then it would be considered unlawful. I hope I said that correctly. So right, this harm-benefit analysis is very fundamental to the dignity concept because of its relative nature. Because dignity can be violated as long as there are serious interests on the other side. There is an enormous weight is put on this harm-benefit analysis, and we'll look into this in a little bit more detail on what it means, and that it's also, to a huge extent, it's very dependent on what society deems okay and what it deems an unjustifiable violation. It all depends on how we as a society view the use of an animal, what we accept and consider to be okay and what we don't. As I was saying, this balancing of user interests, of user interest versus animal dignity is a very important part of the animal dignity concept and its in its application. Animal dignity can be violated in many different ways. There are different elements of stress that can be imposed on an animal that can violate its dignity. So the first type of stress that can be imposed on an animal is the pathocentric, sentientist elements that are very classical forms of violations or classical forms of animal cruelty, let's say, for example, through the infliction of pain, suffering, harm, and fear, dignity violation can exist. So through these very classical and well-known types of stresses. But then there are also these non-sentientist elements that are enshrined in the Animal Welfare Act within Article 3 that says animal dignity can also be violated when non-sentientist elements are present, meaning that it doesn't matter if the animal is actually aware of the violation, and it doesn't matter if the animal is actually feeling any pain, if there's any bodily or psychological harm to the animal, that's irrelevant. It can still be violated in its dignity if the following elements, one or the following, or all of them, or some of them overlap, if they are present in a certain case. So one would be the humiliation of an animal. This means, this is an example of, an animal being used as an accessory, for example, would be a typical non-sentientist stress element and the category of humiliation. And there's also other actions that fall into this category. For example, mocking an animal, making fun of it, putting animals in funny costumes can be questionable, coloring or unnaturally styling their fur, giving them alcohol, tattooing or piercing them, and so on. Arguably, alcohol would probably inflict some form of harm or suffering on the animal, so it would be a combination of a non-sentientist and a sentientist element in that case, or piercing, for example, as well. And so here, it's a huge question of how a society perceives these actions. Take the example of Halloween costumes for dogs and cats, which is very, very big, for example, in the States, right? A lot of money is made off selling Halloween costumes. But then we'd question if that's not to a certain extent a humiliation of the animal. It's also considered humiliation when animals are forced to perform unnatural tricks in circuses, for example, or when they're exhibited in pet stores or at shows without having the possibility to retreat. The other stress element of non-sentientist nature is the substantial interference with the appearance or ability of an animal. And this means an interference with its reproductive ability, with its ability to adapt, with its ability to move, its orientation, its mental capacities or social behaviors when they are impaired. The best example in this case would be excesses in breeding. As you can see, the Sphinx cat, naked cats and dogs are typical examples here. Not only are they exposed to the elements, and again, this could lead to sentientist stress elements when they have skin burn. That's a direct harm being inflicted on the animal, but they also have trouble with orientation. And even if it cannot be proven that they're suffering, that's already considered, because they're so impaired in their species-specific ability, it's considered that it's a non-sentientist stress element that is imposed on them. Another example, typical example, is the dehorning of cows and goats as a typical mass farming practice. And the third one is the excessive instrumentalization of an animal. This is true when an animal is used solely as a means to an end, as an instrument for human purposes, so to speak, whereby the animal is not respected in its core value and is only used for one certain objective. And so here the legislator made the specification with the excessive instrumentalization, because arguably, we would say any form of instrumentalization should be considered a dignity violation, but they said, no, it's only when this is excessive. So what's the difference? What's the difference between instrumentalizing an animal and excessively instrumentalizing an animal? It's all a question of how you define this, but one example would be, for example, if someone buys a specific dog breed in order for this dog to be a watchdog. So they say, I want a watchdog. They tie it outside, they keep it as a watchdog. So, and then the dog doesn't perform well. It's not a good watchdog. It lets people pass through, robbers come in, whatever. It just doesn't perform. It's what it was instrumentalized to do. And what does the owner do? It decides to get rid of this dog, to euthanize it, and buy a new watchdog. So this would be an excessive instrumentalization of the first watchdog, because its sole purpose would have been to serve as a watchdog, and it would not have been respected in its other values as, you know, being an animal with their own experiences and inherent value. And if, let's say, the owner would keep the first dog and say, I'll keep this dog as a companion, but I'll get another dog as a watchdog, then we'd say it was also instrumentalized, the first dog, but it wasn't excessive, because at least it was given the chance to live on as a companion animal. That's, you know, it's kind of a constructed example, but just to show this difference. In practice, it's very difficult. The implementation of these stress elements are far from being implemented correctly by authorities. So this is all, you know, theory we're talking about here. Okay, so again, just to summarize, all these stress elements can be inflicted on an animal if there is justification considered heavy enough on the user side, on the human side. And we would argue, of course, that a circus animal performing to amuse an audience, that's just not a serious enough justification. None of these examples here have serious justifications, in our opinion, the one being an accessory, the other being, you know, a designer breed, and the third being an amusement for an audience. Now, I'd like to give you a couple of examples of different uses or different practices involving animals that potentially constitute a violation or not, depending on how one sees it, or even maybe an unjustifiable violation, meaning a disregard for animal dignity. So the first one would be this cow, and the two obvious problems here are, of course, that it doesn't have its horns and it's wearing tags. So 70 to 90%, sorry. Between 70 and 90% of all calves in Switzerland are dehorned. Their horn base is burned out. And this is done in order to, this is what they say, in order for cows to be able to be handled more, for the safety of the people handling the cows, but most importantly, it's done and to prevent injuries, prevent injuries from the horns, but also economic arguments are very decisive here, because horned animals need much more space. They need better herd management, and barns would have to be designed accordingly. So it's very costly, and it's just easier to dehorn cattle. So we would argue that this is actually a disregard for animal dignity, and it's an unjustifiable violation. And this is something that at least half of the Swiss half of voters, half of the voters who turned up also believed. A little less than half, because it didn't get passed. There was a popular initiative in 2018 in Switzerland meant to protect the dignity of cows, and was known as the Horn Cow Initiative. And it proposed that owners of horn-bearing animals be compensated for allowing these animals to keep their horns. So it didn't even provide for a ban, and it didn't even request a ban of dehorning cattle. It just proposed a compensation for animal owners or keepers that decided to leave the animals with their horns. And even so, it was rejected. And so it goes to show just how far we are from actually implementing these dignity concepts, that we wouldn't, as a society, agree that such a vital organ should be left on an animal, when we agree that it should be respected in its dignity. But that's where we are as a society still, and unfortunately. The Sharpe dog, this stands for cruel breeding practices. And in connection with dignity protection, it's a huge issue. We'll look into it a little bit later. The same goes for the naked, for the Sphinx cat and all these designer dogs and cat breeds, which are designed or which are bred solely for humans and their aesthetic needs. Dairy production as a whole is an important animal dignity issue because of the instrumentalization of cows as milk machines, the use of high-yielding breeds, boosting milk production by feeding protein-enriched feed, which isn't species appropriate, and last but not least, of course, also the issue of separation of mothers and calves. In Switzerland, all these practices aren't really questioned. I think this photo here would be questioned, though. I mean, this specific cow here with this huge udder, this would be deemed to be in violation of animal dignity and potentially an unjustifiable violation, because there are attempts to make it to have smaller udders. But high yielding breeds are still a huge issue, and it's not even being questioned if the separation of calves and mothers is okay. It is being questioned through programs of whereby there are programs where calves are allowed to stay with their mothers for a certain amount of time and allowed to drink from their milk, but it's the minority. Then, as I was mentioning before, dressing up animals in costumes. Admittedly, this is not the most pressing issue we have in the protection of animals, but it's questionable from an animal dignity perspective, especially because its sole purpose is to entertain humans. Even if animals might have some benefit because of all this attention that's being paid to them. Functional clothing, of course, like rain jackets, are something entirely different. They have a purpose to help the animal. So that wouldn't be in the same category. So it's pretty obvious that animals in circuses are violated and arguably disregarded in their dignity. But what about zoos? In our society, zoos are an enormously popular destination, and their existence is often justified, based on species conservation and educational value and so on and so forth. So it's still a widely accepted institution. And I would argue that most animals, especially the ones that aren't indigenous to Switzerland, speaking of Switzerland, that for them, it's not, this is not a place where they should be living. Neither is it for other animals, but especially for animals that are being brought here from a completely different part of the world just to be exhibited. And also the educational value of zoos has been contested many times, as I'm sure most of you are aware. Another absolutely obvious disregard for animal dignity is their use as advertisement space, and it still happens. So it's not something from the past. This milk cow, I think this particular photo is from Germany, but I'll show you later on a case here in Switzerland, very similar case to this one, where a cow was used, where different cows were used as advertisement space. They completely disregard the dignity of animals, because even though the animal is not necessarily harmed, even if they're, the dye that's used is harmless and they're treated well, they are completely instrumentalized and even humiliated, I'd argue, for an economic interest that doesn't even benefit society as a whole. It's just an economic interest of the person advertising their product. So it's a complete disregard of the inherent value of this animal. And also, what about the dignity of animals after death? We argue that, contrary to the popular school of thought within here in Switzerland, concerning the animal dignity protection principle. As I was saying before, we believe that the constitutional dignity concept cannot have a fundamentally different meaning depending on whether it's an animal or a human. Dignity as a term means the same thing. And so we'd say that the legal effect of animal dignity cannot automatically cease to exist after an animal's death. Of course, society has a whole different view on this, as seen with trophies from hunting. It's very popular here in Switzerland as well. People hang up trophies, but from an animal dignity perspective, it's highly questionable. Okay. What are the consequences, especially the legislative consequences of this adoption of animal dignity protection into the Constitution and the Animal Welfare Act? There were certain amendments to the animal welfare legislation, general amendments. One of them being the enactment of statutory bans for certain actions that the legislator considered an absolute disregard for the animal dignity, and exempt these actions from any form of justification, from any balancing of interest from the get-go. So the legislator said, and especially, no, it's more the federal government that enacted the regulatory provisions within the animal welfare ordinance. They said, no, we're banning these actions altogether. And there's a very long list of bans in the animal welfare ordinance. To say something nice about the ordinance as well, because I did tell you that it undermines the Animal Welfare Act to a large extent as well, but it has both sides. There's a long list, but I'm giving you just a few examples here just to show you, just to give you a little bit of a look into what is banned as and is considered as being an unjustifiable violation of animal dignity. One of them would be zoophilia. So until 2008, zoophilia was not explicitly banned. It was only considered animal cruelty if there was proof of actual mistreatment or harm or injury to the animal. So now all sexual acts involving an animal are banned regardless of whether the animal is actually injured or impaired. Also, doping, using performance-enhancing drugs in animals is banned. It should be self-evident, but it's not. There's a ban on sending animals via mail through the postal service. And it was allowed until 2008, actually. But the post office back then had already refused to send around cats and dogs. I'm not quite sure about other animals. I think it was only for cats and dogs. So other animals were still being sent back and forth via postal mail. So now today, in order to transport an animal, you have to have a person responsible for their transport and their well-being from A to destination B. And just so we don't forget this, sending animals via mail is still allowed for all invertebrates. So because they're not protected by the Animal Welfare Act. Another ban is the live feeding of animals, but it is allowed in narrow exceptions for wild animals meant to be released back into the wild, or if an animal refuses to eat anything else. Also, it's, I like this example here, that it's prohibited, it's tail docking, ear and tail docking is prohibited in dogs, and they went that far as far as to prohibit the import of such dogs into Switzerland. So it's only allowed to import a dog with docked tails and with a docked tail or ears if you're carrying a certificate that it had to be done due to illness or an accident. Otherwise, you cannot bring in an animal like that in Switzerland. And I think it kind of shows our species' attitude towards different animal categories, because as we saw before, dehorning cows is allowed, or goats is allowed, but then we'll go so far as to completely ban the import of dogs with docked tails and cropped ears. So we treat companion animals completely differently than we do farm animals, which is not a surprise, but still both are protected by the dignity principle in the Animal Welfare Act, equally protected, and still we treat them differently. Declawing cats is also banned, which should be, again, self-evident, obvious, but it's not. It needed a ban. People were doing it. Other amendments to the animal welfare legislation include a ban on excesses in animal breeding, on certain excesses. So not all, so the legislation categorizes breeding factors in 4 stress categories. So from 0 to 3, breeding outcomes, I mean. And I'll just give you some examples of what might be considered unjustified dignity violation in this context. And I'll also show you some banned breeding outcomes that are entirely banned. However, when it comes to certain socially accepted breeding practices, as is the case with all these bulldog breeds or pugs, all these short-faced breeds, they are all so commonplace and have not been banned entirely, and it's very difficult to follow, to trace back where these dogs have come from, how they have been bred, and to actually enforce this ban on excess and cruel breeding, which is it's a ban in the Animal Welfare Act. And it's also worth mentioning that the Animal Welfare Act exempts laboratory animals from this ban on breeding excesses. So laboratory animals are seen as being a different issue, and so different rules apply to them. As I was saying, the law distinguishes between 4 stress categories, ranging from 0 being the least invasive or least problematic, to 3 being the worst breeding outcome, meaning that it leads to bodily and psychological problems, physical and psychological problems for the animals concerned. I won't go into the details because we just don't have the time, but I'll show you some images that give you an idea of where this legislation is applicable. And it's worth noting that in all of these cases, ownership is always allowed. It's just the breeding that might be unlawful, which makes enforcement of this legislation, as I was saying, extremely difficult. So we have the facial deformities in dogs and cats that lead to respiratory problems. I don't know if I'm pronouncing it correctly in English. Brachycephalic dogs? I hope I am. But this would be this issue they're having. And so depending on how serious it is, their breeding would be unlawful. But not all bulldogs are considered torture breeds, right? So it's very difficult to follow through. The same goes for, once again, Sphinx cats and naked dogs, which, by the way, used to be banned in Switzerland, but breeders were able to achieve a rollback to achieve their ban was lifted again. So now they're allowed. It's allowed to breed these types of animals again. It's not allowed. It's prohibited to breed bubble eye goldfish in Switzerland. It's one example, because it's only done because they're considered funny, and they have a huge constant risk of injury. For me, it doesn't really make sense why one would be prohibited and the other, for example, the naked cats would not. It's just arbitrary implementation within the Animal Welfare Act. The Belgian blue beef cow breed, as it's called, is banned in Switzerland in its purest form, and its purebred form, I mean. But again, not the ownership. They wanted to breed with as much muscle and lean meat as possible. And so this animal breed is banned, but broiler chickens aren't, and they're still being used in factory farms in Switzerland. These fast-growing chicken the types that are being used, breeds. These fast-growing breeds, I'm sorry, where they can hardly stand on their legs after just a few weeks, and they have bodily deformities and respiratory problems and so on and so forth, but it's still considered acceptable because the agricultural industries have such a big interest in keeping these breeds. Another dog issue, German Shepherds, for example, and their joint problems. There are so many dog issues out there. I'm sure you're all aware of them. But again, here it depends what category, how bad the joint problem is. If not all German Shepherds, again, are considered to be torture breeds. It really depends on how far the joint problems have gone and how much they impair the animal. Waltzing mice are, the breeding of waltzing mice is prohibited in Switzerland. It's a syndrome. They have the syndrome. They're a genetic variant that has an inability to walk straight. And so they whirl in circles. Same goes for kangaroo cats. Breeding is prohibited. For teacup dogs, the breeding is prohibited. For dogs that are under 1.5 kilograms, and for reptiles with the Enigma syndrome, which affects their balance, similar to the waltzing mice, and they exhibit stargazing and run in circles. Some people really look for these animals and want to have them. Another consequence, which I think is worth mentioning, is the fact that another consequence of animal dignity protection was the fact that social animals had to be kept in pairs or groups at one point. It was decided on this, and it was a huge benefit for the animals involved, because so many animal types, especially hamsters and different bird types that are kept in homes, are kept alone. And this still happens. Enforcement is lacking there, absolutely, but it's at least it's something, it's prohibited. So if people are caught keeping these animals on their own, they will be punished. They will be made to at least, or before they're punished, they will be obligated to take in at least a second animal. Internationally, the international attention this got, it was seen as quite ridiculous. Maybe you've heard of it. It just goes to show how around the world we're still, we see things as ridiculous that are so basic, and go so far in the protection of the most defenseless. Then another consequence, well, it's not a direct consequence. This is something I have to mention before I go into it. This is not a direct consequence. This amendment to the civil law, certain civil law rules were changed with respect to animals compared to how they're used with respect to objects. And it's this new rule is not a direct consequence of the animal dignity principle, but it is linked to it, because prior to the inception of the following article, Article 641 of the Swiss Civil Code, which stated that animals are not objects, this happened in 2003. Prior to its inception, the Amendment Act explicitly explicitly mentioned the constitutional principle of protection of animal dignity, and that animals are not to be considered objects or things because they have an inherent value, because they have dignity that is protected on a constitutional level. And so in a certain way, these were related. This change, this amendment to the civil law, to the civil code, was related to the dignity concept. The legal status of animals today is somewhere between persons and objects. So they didn't acquire legal personhood in any way. So there was no fundamental reform to the basic structures and functions of property law. Animals are still considered property, but there were amendments to inheritance law, to rules governing acquisition of animals, to the allocation after divorce or dissolution of cohabitation, to compensation claims for injury and death, and so on and so forth. For example, one example would be the allocation after divorce. Nowadays, a judge would rule that after a divorce, the animal is to be allocated to the person that is best suited to take care of the animal after the separation of two people. So no matter who brought in the animal in the beginning, as long as both parties took care of the animal, as long as the animal was taken care of by both people in a relationship, they will be allocated to the person that is best suited afterwards, and not necessarily to the one originally considered to be the owner. So that was an improvement, and there are many more such improvements. But it's very typical again that these amendments were highly anthropocentric, because they only qualified or classified only these animals as especially valuable, the ones that have worth from a human perspective and that are considered companions. So farm animals were completely excluded from these changes, and the changes only apply to companion animals that are kept within the household out of interest, for an emotional value. But let's say if a farm couple divorces, the animals will be allocated to whoever had signed the contract, to whoever was originally considered to be the owner, no matter if they're actually capable of taking care of those animals or not. So again, a highly speciesist change here. Okay, then another crucial amendment was to the criminal provision, the criminal provisions within the Animal Welfare Act. So animal cruelty in general is considered punishable, but so now is the disregard for animal dignity. And so the penalty is a custodial sentence of up to 3 years, or a monetary penalty for any person who intentionally mistreats, neglects, unnecessarily overexerts an animal, or disregards its dignity in any other way, meaning in all those ways we saw before, where non-sentient stress factors are involved. It's considered an animal cruelty, an act of animal cruelty. So this the disregard for animal dignity, and can be punished very strictly. But in as we'll see later on, or in just a bit, in practice, the enforcement is almost inexistent. Sorry. So here we are, the application in practice. This all sounds quite nice, even though from an animal rights perspective, or not animal rights perspective, I mean, from the perspective of someone really interested in improving the well-being of animals and in actually having, rights enacted for animals, I find that our legislation is not anywhere where it should be or where it could be. But of course, it still is a very, the protection of the fact that we protect animal dignity and have this on a constitutional level and within the Animal Welfare Act is very, it's very far reaching, and it's so implemented correctly, it could actually, be compared to actual animal rights if we would actually think it through and implement it the way it should be implemented, and if we wouldn't make it so relative. But it is relative. This is what it is, and it's still, very. It's still quite, quite a huge step forward in the improvement of the situation for animals. But practice and enforcement is a completely different issue, and there's a huge lack in Switzerland too, where we have pretty well functioning services, veterinary services, prosecution, and criminal authorities, and so on and so forth. There is a huge lack of knowledge, first of all. That's why enforcement is so bad, and also of interest in these issues, unfortunately. So in practice, what do we have? Animals, the human interests are usually weighed much more heavily than the interests of the animals involved. And I'd like to give you some examples of court decisions and go into court practice in Switzerland. First off, the disregard for animal dignity, that criminal provision is hardly ever looked into, hardly ever prosecuted. There are hardly any decisions on the disregard for animal dignity in it's hardly ever mentioned in court cases. Not to mention cases of disregard for animal dignity where only non-sentient stress elements were involved. There are even less cases like that. But even in the most obvious animal cruelty cases, where we're talking classical cruelty cases of pain infliction, of mistreatment, torture, even in those obvious cases of blatant animal cruelty, authorities and prosecution hardly pay attention to them, and proceedings are terminated. And if they are conducted in the first place, the verdict is usually acquittal, or the penalties imposed are so ridiculously low that it's just, it's clear that these cases are trivialized, and they do little to deter further cruelty to animals. What I'd like to note in this context is the fact that in Swiss criminal law, prosecutors have power to hand down verdicts. And actually, over 90% of sentences in Swiss legal cases are handed down by a prosecutor rather than a judge. These so-called sentence orders are, this is done because they are cost-effective and they speed up procedures, but they are highly controversial in light of the separation of powers principle. Prosecutors can impose prison sentences of up to 6 months, as well as fines and penalties, if they deem them to be sufficient. So because animal cruelty cases are hardly ever taken seriously in the first place, prosecutors primarily impose penalties and fines, even though they could impose custodial sentences, as we saw in this criminal provision. And prison sentences of more than 6 months are never imposed, if they're imposed at all. So that usually, the defendants in other cases, because this is throughout the criminal law system in Switzerland, this is true throughout the system, usually the defendant has a right to appeal against a sentence order to a court. But this right to appeal doesn't pertain to animals. They don't have that right to appeal. Neither do animal rights organizations who could do that on their behalf. So what happens is that prosecutors have this huge power in these situations. I mean, I could go into more detail that veterinary services do have a certain right to appeal in certain cantons, but they, first of all, that's not, their main area of work. That's not their main area of interest. They're not primarily interested in safeguarding, the protections of animals in criminal cases. They have so much other things to do. So it's a highly questionable situation that happens here. Prosecutors handing down verdicts and not courts, and then no possibility to appeal these verdicts. So there we have these cases where we have a big database in our foundation where we register all the penal cases, the criminal cases that have been decided on throughout the year, and we analyze them and try to see how they've been decided on. Look at the average fines that have been passed down, and usually they're it's just throughout the entire throughout Switzerland, the fines are very low, they're trivial. And I wanted to give you an example of, I wrote fish cases here as an example because I'm sure you're all aware of the fact that most people can't relate much to fish, and there's still a widespread belief that fish aren't really sentient, or that they don't feel pain, even though that's not true, and it's proven that they do, and they are vertebrates, so they are protected by the Animal Welfare Act. And yet authorities find it very, very difficult to sympathize and to sentence perpetrators accordingly. And so our foundation has reported numerous cases of animal cruelty involving fish in the past years, just because we want to show, hey, these cases need to be looked into. So we have a right, of course, to report such cases. This right pertains to everybody. We can't appeal them, but we can report them to the competent authorities. Well, in most of these cases, the prosecution issued no proceedings orders, or they abandoned the proceedings for, quote, lack of evidence of an offense, unquote, without ever actually beginning to even investigate the cases, just to show you how little attention is, and how trivial they find them to be. So there's just one case from 2022, which we were, so not used to that we were happy about it, even though it was a fine of 400 Swiss francs, which was, laughable. But it was a video showing a person, pulling a fish out of water, putting it in a bucket without water, letting it almost suffocate to death. And then after quite some time, grabbing it by the gills and throwing it back in the water. So first of all, that's obvious animal cruelty. Second, catch and release is prohibited in Switzerland. It's one of those prohibitions I didn't mention before, but it's on that list. And so this is like this huge stress imposed on this animal. It's being tortured, literally tortured. And we weren't even expecting the prosecution to do anything, to be quite honest. And we're happy that 400 francs were being imposed. So just to show you, how this is not really being taken seriously at all. And in most cases, as I was saying before, only sentient distress elements are actually looked at. Any other form of animal dignity violation, non-sentient distress elements are hardly looked into. But I would like to take a closer look at some recent and not so recent court decisions that do relate to animal dignity, and in which animal dignity was either ignored or surprisingly and fortunately acknowledged. One of the most famous case would be a case concerning the use of primates in research from 2009, whereby this case was brought all the way up to the Supreme Court, because first, members of the experiment committee that were to decide on the admissibility or permissibility of the case had filed a complaint against the decision of the veterinary services to approve the case. The veterinary services approved the case. So the experimentation committee filed a complaint against this decision with the competent health authority, which approved the complaint and revoked the experiment approval. The researchers then went on and took the case to the administrative court in Zurich and so on. The administrative court rejected the complaint, and they went all the way up to the federal Supreme Court. And the Supreme Court took a seminal decision and set an important precedent for animal welfare law, because Supreme Court decisions do carry weight as precedents, even in civil law traditions. So it was quite it's usually other lower courts are bound by Supreme Court decisions, if cases are very similar, or if they have the same type of case. And so what the Supreme Court decided and argued was that the experiments would subject the primates to extreme stress, and that more weight was to be placed on the protection of their dignity because of the uncertainty of the outcome of the planned experiments. This was huge. Here they are saying, that we're in a country, Switzerland, where we have a huge pharmaceutical sector. And as I was saying, animal experiments are almost always approved. And here we have the federal Supreme Court saying, no, it's highly stressful experiments with primates. Of course, there was some anthropocentrism to the decision because they said primates are so similar to humans that we cannot have this extreme stress imposed on them, especially because it was a basic research experiment, and so there's a huge uncertainty as to the outcome of basic research in general, and so the Supreme Court actually defended this argument by the animal interest side. Unfortunately, what happened is in 2017, the same administrative court of Zurich that had originally revoked the experimentation approval, that originally, rejected the complaint by the researchers, went on to approve a highly stressful experiment with primates that was so similar to the one planned in 2019. And what's interesting and quite disturbing in this case is the fact that the court actually agreed with most of the arguments put forward by the animal welfare representatives, and classified the experiments. We're talking about, 2017 now. They actually agreed that the experiment is highly stressful and the medical significance of the primate experiment would be very uncertain. The outcome would be uncertain. There would be uncertainty as to the benefits. And so they admitted all this, and nevertheless, if you look at their reasoning within the decision, nevertheless, the administrative court concluded that the research benefit would outweigh the stress for the animals and went on to approve the experiment anyway. So we have all this, yes, you're right. There's no certain outcome. The stress is extreme. It's almost the same case as in 2009. Yes. Still, the research benefit justifies the stress for the animals. And this constitutes an absolutely unlawful political decision by a court, and shows how courts have come to decide in favor of research, in favor of these interests, research interests, even in cases in which they admit to the fact that the dignity of the animals involved carries more weight than the anticipated outcome of the experiment. So, even though we have this precedent, it's not being followed. And there was no way to contest, to appeal this decision in 2017, because it was the other way around. It would have, the animal interest side would have had to appeal. And as we don't have, as animals don't have a right to appeal, it was impossible for them to bring it to the federal Supreme Court, which is an even greater imbalance in this whole situation. Yes, another case, which was also completely ignored by the authorities, was following a criminal complaint by our foundation against a circus act involving lions. On the grounds of disregard for animal dignity, we went and watched that circus act and were absolutely, certain that it's, there's no justification for what was being done to these animals within the scope of this circus trick. They were being kept in very tight holding pens. They were being, subjected to these demeaning tricks. They were being whipped, but then petted and whipped again. It was just, and what the prosecutor did was issue a no proceedings order because they were of the opinion that the circus obviously did not violate animal dignity, but they actually never investigated the case in the first place to be able to make this verdict. There was no investigation, and still they're saying there's obviously no violation of animal dignity. So yeah, that case was that. And then on a positive note, there was a recent case which made the local news and maybe even international news, I'm not sure. And it concerns the use of live cows by a farmer to promote his beef label, Appenzeller beef. He dyed, he used hair dye to paint Appenzeller beef on the sides of cows, so they weren't harmed in any way. But In our complaint, we elaborated on the fact that they were being, instrumentalized as advertisement billboards, and that it's an absolute disregard for their animal dignity. And actually, the prosecutor agreed. Prosecution. So it really, really depends how you have, in these sitting in these prosecution offices. They agreed and they issued, I mean, not a very high penalty, but they did issue a conditional penalty and a fine of 1,400 francs, which is quite high considering the fact that I think the medium fine that's issued at the average is like, I'm not completely sure, but I'd have to ask our experts in our foundation, but I think somewhere between 300 and 500 francs. So it was a pretty high fine. Okay. So I'd like to go into some recent developments that directly or indirectly relate to animal dignity. The first one being an initiative to enshrine fundamental rights for primates, for non-human primates, in a cantonal constitution. So it's not directly linked to animal dignity, but it does have an indirect, it's indirectly connected. This initiative was launched by Sentience. Sentience is a think tank and nonprofit organization in Switzerland that uses direct democratic means to achieve change for animals on a communal, cantonal, and national level. And they focus on agriculture, consumption, and animal dignity in general. And so they were behind this this initiative. I'm sure you're all aware of no, I'm sorry, I can't find it right here. Yes, they were behind this initiative, and they wanted to they launched a citizens initiative in the canton of Basel City to amend the cantonal constitution, which one can compare with a constitution of a US state. So it's not a federal constitution, it's a cantonal one. The initiative specifically demanded that the existing rights catalog of the constitution be complemented by a fundamental right to life and to bodily and mental integrity for non-human primates. In other words, the right not to be killed, the right not to be held in captivity or experimented on. And if it had been implemented, so it was not accepted. It was actually, this initiative was rejected by the Basel City population. But had it been implemented, the initiative would have been binding for all the public authorities and institutions of the canton. So it would have had this vertical effect, right? As do other fundamental rights in constitutions. They have this effect that they protect from state interference. They give the holder of these rights enforceable rights against the state. And so it's also worth mentioning that the initiative, or if had it been enacted, it would not have had a direct impact on private persons, because again, it would have enacted fundamental rights as against the as a means to as a help against state force. So private research companies, for example, just private persons in general would have still been able to continue, would have still been able to keep primates in captivity and use them, and so on and so forth. So there was a limited scope to how far-reaching this initiative would have been. But at the same time, I'm explaining all of this because it still scared everybody. Even though it would have had such a limited scope, it was the fight against it was huge. The opposition, was huge. And there was this general fear that we wouldn't be able to have any more primates in zoos, and that this would open the door to further the enactment of even more enforceable rights, and that, you know, there would be this clear you know, line between humans and animals would be diluted, and it was just, you know, the opposition was enormous. Not to mention the fact that Basel City is home to one of Switzerland's most popular zoos, and they had, you know, they were very, very they were very constantly fighting against this initiative. And it's also the country's pharmaceutical capital. So, you know, it was clear that there was no way they wanted this initiative to be passed, even though, you know, private research institutions would have still been able to use primates. But let's say the university, which at this moment did not use any primates, but it could have at any point again begin to use primates in research, the university would have been bound by this initiative. It was the first initiative of its kind in the world, and yes, I'm pretty sure you've all heard of it because of this. And in February of 2022, 74% of voters voted against, and there was 51% voter turnout. So it was quite a high, quite many, you know, 74% voting against, you know, was quite a clear statement against the initiative, unfortunately. And then the last one I'd like to go into, so I am still currently on the board of the Factory Farming Initiative, but it was passed in September 25. So this initiative was already decided on. And again, it was launched by Sentience and through a connected association to ban factory farming in Switzerland, which I was on the board of. This is what Laura was mentioning in the beginning, but the minds behind this initiative were, again, Sentience, this organization, the think tank I was mentioning before. And the initiative was actually, this initiative to ban factory farming and factory farming practices in Switzerland was directly supported by an alliance of animal welfare, animal rights organizations, environmental organizations, and agricultural organizations, as well as political parties. So there was a big, huge, widespread support for this initiative. It aimed at enshrining farm animal dignity into the Constitution. Even though animal dignity or dignity of living beings was already enshrined in the Constitution, it wanted to emphasize the dignity of farm animals because of the fact that they're the most exploited animals, or animal category in our society. So it was important to emphasize that they too are protected in their dignity. And so it was, it would have been huge if it would have been passed, and there were so many people actually supporting this initiative. It looked pretty good for quite some time. And so what it wanted was to enshrine this farm animal dignity into the Constitution and the entitlement of these animals to not live in intensive factory farming conditions. The intention was to emphasize, the intention was, the initiative specifically demanded smaller group sizes on farms, more room per animal, adequate straw bedding for all animals, opportunities to play, species appropriate feed, daily access to a grazing area, the use of slower growing breeds that could actually, use this outdoor access area, because nowadays only 12% of animals actually have access to the outdoors, farm animals, I mean, but most of them can't actually use it because of their bodily deformities. And again, I'm talking broiler chickens here, especially, in particular, I mean. Then it wanted to enact, or it demanded the humane slaughter by way of shorter transports, better slaughter methods, and better monitoring of stunning results. Because according to a somewhat recent study, a federal study, an inspection was done of 10% of all slaughterhouses in Switzerland, and deficiencies were found in almost all of the controlled slaughterhouses. Deficiencies were found in the stunning and bleeding process. So the humane slaughter was to be enshrined in the Constitution. And I'm emphasizing this because, admittedly, in hindsight, it seems quite counterintuitive to enshrine the humane slaughter of animals and their dignity at the same time. It's very contradictory, and it doesn't sit right with me anymore in hindsight. But you know, we learn things in hindsight. But at the same time, I have to to emphasize the fact that this was it was so difficult to get so many people on board this initiative, to get so many people to back it. So it was a compromise. All these things that that's why I was spelling out what it was demanding in particular. It's not that far reaching, because it was supposed to get as many stakeholders on board as possible. So there had to be compromise. So that's why, there were also many people, many animal rights activists and people working in the animal rights field that were against the initiative, and we're saying we are going to institutionalize, the use and the slaughter of animals in our Constitution. That's not right, we're going to be able, if this gets accepted, people are going to say, well, we actually have a guarantee that animals don't live in factory farms in Switzerland. So I get that. I'm just showing you both sides. But there was also what was also being asked for, in the initiative, there was also demand for import restrictions so that products wouldn't be imported from outside of Switzerland to flood our market, products that are, products of factory farming. Opponents of the initiative, went with this mantra: we have the best animal welfare acts in the world, and we don't have factory farms in Switzerland compared to other countries, and kept selling this pervasive lie that Swiss farm animals are living the dream. And this lie is actually perpetuated by advertisements that are funded by taxpayers in Switzerland. It's also, on a side note. Also, the opponents were financially much better off to lead the opposition campaign and to spread misinformation. And they also warned that the change would lead to higher prices, reduced consumer choices, and floods of foreign products that would arrive into this country, even though the initiative contains, this clause of restricting and prohibiting imports from factory farming. It didn't matter, as long as they, spewed these lies. They were, they worked. What's also worth mentioning, and we still have, I still haven't had the chance. This just happened. Well, it's not that recent anymore, but it was on the 25th of September. We still haven't had the chance to talk about this in more detail, but it's a huge issue that the government printed misleading numbers in the informational booklet, which the government is obligated to provide prior to any votes, public votes, so that voters can make well-informed choices and decisions. And the Federal Council used misleading numbers that sugarcoated the current situation of Swiss animals, which also, led to this outcome, led to the initiative being rejected, because they claimed that 4 out of 5 animals in Swiss agriculture have outdoor access, which just isn't true. It's not true. The statement is false. And the reason that they could write this and say that 4 out of 5 animals have access to the outdoors, the real number is 12% of all animals have access to the outdoors. This is due to the fact that the Federal Council did not count animals as individuals, but counted them in so-called livestock units. 1 cow corresponds to 1 livestock unit, 1 pig to 0.17 livestock units, and 1 chicken to 0.004 livestock units. Just to put this into perspective, I'll give you an example. If a farmer's family keeps 500 broiler chickens without outdoor access and 2 cows that are allowed to graze on a pasture, this results, according to the federal government's calculation method, in 50% of the animals mentioned having outdoor access. But in fact, that's not true. You have 500 broiler chickens living inside and 2 cows, and they can claim that 50% of the animals on that farm have access to the outdoors. And this is what they did on a huge scale in this informational booklet. And so the damage was done. People were reading this and thinking, oh, it's fine. These animal rights activists, they're going nuts again. And, our animals are doing great. And all these things, this all led to the initiative being turned down. At least 63%. It's bad, but it could have been worse. If you look at the animal, the more or less recent initiative to ban animal experiments in Switzerland. Admittedly, it was a very poorly thought through initiative. There was no way it could have been passed, but it was, I think, rejected because it wanted to ban all forms of experiments with animals and humans, all just at once, and it doesn't work, would have never worked. There was no compromise there, and so it was politically impossible to pass. But I think it was rejected by more than 80% of the voters. So 63% is bad, but at least it brought this is a very important initiative, the factory farming initiative, because it brought this factory farming subject, to the general public, to people who never, ever, have anything to do with, never think of these subjects, never think of, animal welfare. And so I think it was really important in changing perspectives. Yes, now I've been speaking for so long. I hope I haven't bored you all, and I have come to the end of my my talk. And I'm open for questions, I hope, and for a discussion.
That was brilliant, Kate. Thank you so much. I particularly enjoyed hearing about the recent case law as well, and the philosophical angle behind animal dignity as well. It was really interesting. Thank you.
Thank you so much.
We've had quite a few questions come through in the Q&A. I'm conscious of time, so I don't think we'll manage to get to all of them. But there are a couple if you're happy to hang on.
Just I'm happy to answer questions later on via email if anybody would be interested. Sorry, because this is because of me, because I took so long. No. Just to tell you, yes.
Not at all, not at all. It was all really interesting. So thank you. So the first question we've had in is, would you eat a dog? Is a standard anti-meat argument in the West, but in Switzerland it is legal to kill and eat dogs. I'd be interested to know whether there are any moves to outlaw the slaughter of dogs in Switzerland, and whether outlawing dog meat could be a gateway to further animal rights legislation covering other species.
There's the food. There's legislation on what is considered food, and so dogs and cats are not in that legislation. They're not listed there. So it's not prohibited to kill a dog and eat it, but you couldn't sell it to the general population. So in that sense, yes, it's legal, but it's not necessarily, it would be illegal to sell it to the general population because it's not considered a foodstuff. So, I mean, it's difficult for me to say, for the purpose of food production, in our best interest, I would, in my opinion, that would be kind of a speciesist approach, to say, I get it, I get where it's coming from, but to say, let's ban eating dogs and cats, because it's technically, it already is illegal in a sense. So I'd have to think about that. I don't know if that would, be a way of reduction, if that would be a way to go. I'm not sure.
Thank you very much, Kate. That was a really interesting perspective on that one. A second question that we've had in is, to what extent is intent taken into consideration concerning the determination of an animal's dignity and whether it's been violated? And for example, would a case be judged differently from a legal perspective if an animal was dressed up by its owner to be used as entertainment for other humans versus because the owner supposedly perceived the animal as thoroughly enjoying being pampered and played with through being dressed up?
I think that's a really, really good question, because intent is usually the only area where intent plays a role is within the wanton killing of an animal that I was explaining. But in this here, I think it definitely would play a role. I think, and it certainly should play a role, because it's an entirely different situation, right? So if you're dressing up an animal just to use it as, as you're writing here, as entertainment for other humans, as opposed to dressing it up because the animal enjoys it and you're doing it for yourself, it's a whole different situation. The animal is not, it's not being publicly humiliated. It's not, you're not sending out the message that it's okay to use an animal as like a doll or a plaything. So yes, I do think intent should and is, if properly applied, taken into consideration.
Thank you. And another one, if you're okay to hang on, Kate.
Yes, go ahead. I'm all ears.
So given where we are with the egregious welfare harms routinely inflicted on animals, and given that there is limited political and public will and bandwidth to help animals, should we be devoting time to debate whether animals should be protected from things they don't even suffer in the literal sense, like being written on in adverts? And couldn't many of the consequences, which are all fabulous, been arrived at via traditional welfare argumentation?
I think yes, to a huge extent, we're not there yet at all as a society. Absolutely not. And it could be argued that it's kind of, it's a luxury to even be discussing these things. But especially if you're mentioning, using animals as advertisements, I think that one is a good example for animal use. That's, what kind of message is that sending? Even if the animal isn't harmed, it's sending a message. I mean, a cow is advertising its own beef, its own flesh. I think that is, it's such a powerful message telling us that it's okay to instrumentalize animals. So even if this specific animal isn't really harmed bodily or psychologically, I do think that this can cause an enormous amount of damage, because it gives society or people that see this, the idea that this is okay. This is okay to treat animals that way. It's okay to eat them. It's okay to use them as an advertisement. It's okay to disrespect them in the furthest sense. So I really do think it depends which sentientist aspects we're looking at, non-sentientist aspects we're looking at. And I agree, as I was saying, some things really aren't the most pressing issues, while others arguably, or in my opinion, are.
That's great. Thank you very much, Kate. I think that's all we've got time for. I'm really sorry if we didn't get a chance to ask your question, but please do feel free, if you've thought of anything else as well, to email us using the email address in the chat box, and we can make sure we pass those over to Kate and get those answered for you. So I think it just leaves me to say thank you very much to everybody for joining us this evening and for your great questions, and a really special thanks to Kate for what I'm sure everyone will agree was a fantastic presentation on a really inspiring and thought-provoking topic. So thank you very much.
Thank you so much, everyone.
Thanks. Thank you.